The next one I'll get into here are LLCs. So LLCs are pretty prominent in this area. We have a lot of investor buyers. So who can sign for an LLC? So you would need either the manager of the LLC, or if there's multiple members of the LLC, the documents for the LLC should set forth who is kind of the authorized signatory or the acting manager on behalf of all of the other members. There are also scenarios where you may have multiple members that need to come together to sign together. So what you'll need kind of at your listing agreement stages is you'll need the articles of organization. So those are the filing with the state that shows that the entity is registered in that state. The operating agreement is something that will lay out exactly how the LLC works. So I'll preface this with many sole member LLCs, meaning there's only one member of the LLC, do not carry an operating agreement because they're not required to. It's understood that since there's one person as a member of the LLC, that one person obviously then has the authority to go ahead and act on behalf of the LLC. There are other scenarios where you may have multiple members. So in this multiple member scenario, they should always have an operating agreement. So the operating agreement will set forth kind of the membership here, the responsibilities of the membership, and then who is authorized to sell. So you'll look to the operating agreement to see who is authorized to act on behalf of the LLC. If you have a scenario where you have a multiple member LLC where members, let's say, are strewn about the country and not everyone is able to sign or not everyone is willing to sign. What you can have done in a scenario where every member needs to go ahead and sign everything to convey is you can ask the members to execute a resolution. So the resolution will be a kind of a meeting of the members of the LLC where they will all agree on one person that's able to act on behalf of the LLC, and then they'll just go ahead and finalize the resolution. And then moving forward, you can have that person go ahead and sign your listing agreement, sign the contract, and move forward to closing, dealing just the one member. So again, with signing here for LLCs, it's as simple as John Doe, managing member, or authorized signatory if it's a resolution where they haven't been granted, let's say, a managing position with the LLC, they're just authorized to sign, then you'll go ahead and note there. In worst case, you can always default here to authorized signatory. With corporations, we don't deal with corporations a ton in this area, but they do come up every now and again. So corporations will have a set list of people who are authorized on behalf of the corporation. So you'll have officers, most typically. So your president could be CEO, CFO, secretary, etc. So these officers are authorized by the board of directors for the corporation to go ahead and act in their respective roles. So when you go to sign a listing for a corporation, or you go further with the contract, you'll need the corporate bylaws and the articles of incorporation, and that's going to show officer authority. And then most often when it comes to a corporation, you will have a board resolution that gives one officer authority over the others to go ahead and act on behalf of the corporation. In most scenarios that we see, it's going to be the president of the company or the CEO of the company. Sometimes here and there it could be a CFO or a secretary. But you'll need those documents in advance before you start moving forward, because it can really cause a nightmare scenario. And it sounds like, oh, this is kind of routine, but it does happen quite often. And obviously we see kind of a broader market picture when it comes to entities constantly. And we see these pitfalls quite often when it comes to entity sellers.